Oh, Senator Waso is item 12. Senator Waso, SB 603.
Good morning, Madam Chair, Senators. At your direction, Madam Chair.
Yes, please.
Thank you. In light of National Victims' Rights Week, I'm proud to present SB 603. This bill would set up a legal framework to further prevent trauma to specified victims when their accuser, attacker, is representing themselves in court. Now, this bill does not assume that the defendant in a case is guilty. That's why a state law is required. Currently, a federal judge could create a process to lessen the trauma on a witness should they be called to the stand by their alleged the person that is that allegedly victimized them when that defendant is representing themselves in court. When they don't have an attorney, just to present the scenario, we could have a person that's being accused of victimizing somebody in a case where there's bodily harm to somebody who is representing themselves in court that could call the plaintiff up to the stand, and they could ask him questions. They can it can be a potentially traumatic effect. It could create a scenario in the courtroom in which the plaintiff's altered state of mind because of the person who's questioning them could create a problem in the way they introduce testimony, simply because they're emotional at the time of the cross-examination or the examination. This bill, while a judge could decide that, this bill would set up a legal framework to lessen the conditions in which a jury could be influenced. And let me explain that part. Where a state law is required in a procedure, that could be used to lessen the image that the victimizer is guilty, but it will also provide emotional protection to the plaintiff who is at the stand. So overall, this bill protects both. In an alternative scenario, a judge could say, you know, that to protect the victim, that there would have to be a court. You know, he would basically take the same role, but in a jury, it could necessarily make the jury feel that the attacker is already guilty. When there's a state law involved, the judge could invoke state law and invoke the process to ensure that there's fairness all around. So the judge could use a court-appointed person just to read the questions, just to serve as an interpreter to the questions and to administer them at the time of examination to the plaintiff. Or the judge could ask the questions themselves, and he could explain to the jury that is a state law that requires that, and that would remove any kind of prejudice in the proceedings. So we have some representatives from the San Diego District Attorney's Office who've asked me to work with them on this bill to protect any victims and also to protect the integrity of the judicial process. And they're here to expand on my comments.
Madam Chair, I'm prepared to move the bill when you're ready.
Thank you. We will have two witnesses for a minute each, no more than a minute each.
Okay. Thank you, Madam Chair and members. I am Judy Tashner, a Deputy District Attorney at the San Diego County District Attorney's Office. I'm here on behalf of DA Bonnie Dumanis, the sponsor of the bill. As a Deputy District Attorney, I prosecute such crimes as rape, child molest, stalking, and human trafficking. I have seen the struggles and trauma that these victims suffer and the impact on their lives. The trauma comes not just from the crime itself, but also from the criminal court process during their pursuit of justice. SB 603 is needed to prevent further trauma to our most vulnerable victims when their attacker is acting as his or her own attorney. We have narrowed this bill to the most sensitive of cases: felonies involving sex crimes, child abuse, stalking, elder abuse, and domestic violence. We have worked with your staff, your consultants, and reached out to the ACLU and the defense to address concerns that they might have with this bill, and we have taken amendments. We recognize and honor defendants' rights to self-representation and to confront and cross-examine witnesses, but those rights are not absolute and at times can be outweighed by a compelling state interest. SB 603 protects those rights of a defendant by requiring specific factual findings before this procedure is used and allows for the defendant to maintain control of his case and have all of his questions asked. In 2008, the people of the state of California approved the Victims' Bill of Rights, Marsy's Law, which amended the California Constitution to provide additional rights to crime victims. Among them, the right to be treated with fairness and respect for his or her privacy and dignity, to be free from intimidation, harassment, and abuse throughout the criminal justice process, and to be reasonably protected from the defendant. SB 603 honors that commitment to victims' rights. While there are other protections in place, nothing addresses this specific issue to prevent this trauma before it occurs. A pro per defendant does not have to ask improper or badgering questions to inflict abuse. Power and control is often exerted in very subtle ways. The courtroom should be a place where victims are safe, a place where they can finally reclaim some of their dignity that was so violently taken from them, and I respectfully urge your aye vote. I have with me Jessica W., who has experienced this in her rape trial, and she would like to address you at this time.
Thank you, Madam Chair and members. My name is Jessica W. On March 23rd of 2013, I was sexually assaulted by a complete stranger. I'd met this young man only minutes before he suddenly decided to beat me over the head with his fists. He dragged me behind an empty building, and I continued to scream for help as he tore off my clothes and he raped me. He robbed me of all my belongings, even my clothes. I was forced to run half naked to a nearby store, screaming at the top of my lungs, "Please help me, I've just been raped." It took only an hour for me to be stripped of my freedom, my peace of mind, and my humanity. Thankfully, my rapist was caught and arrested, and we went to trial. A week before trial, the DA informed me that my rapist had decided to represent himself in court. At that moment, I found myself questioning my ability to stand trial, as the anxiety and fear surrounding answering his questions and just being in the same room with him was drastically amplified. I began to suffer from horrible panic attacks at night leading up to trial, and I had to go to the emergency room. On the day of the trial, my rapist had the chance to look me in the eye and ask me direct questions about what happened that night that he so brutally attacked me. Answering questions from his mouth was one of the hardest things I have ever had to do. After going through this whole process, I am still in treatment to this day for PTSD. I want to stress that defendants do have rights, but victims have rights too. I'm not just a victim or a witness, I'm a human being who had to live through this. SB 603 will prevent further harm to people such as myself who have had to endure unspeakable crimes. This legislature has the power to prevent this trauma and give some peace of mind back to the victim. I urge you to vote aye on SB 603. Thank you.
Thank you. Others in support? If you'd
Marty Varenikar, on behalf of the California District Attorneys Association, we're in strong support of this measure.
Thank you, Madam Chair. Members, Dawn Kepke with McHugh Kepke and Associates on behalf of Crime Victims United of California, also in strong support.
Thank you. Others?
Roanne Dozier on the behalf of Anne-Marie Schubert, District Attorney for Sacramento County, in strong support.
Thank you. Are there others in support? Seeing and hearing none, are there speakers in opposition to the bill? Please come forward. To two speakers, a minute each.
Good morning. Natasha Minsker on behalf of the American Civil Liberties Union of California, and regretfully, we are opposed. We do understand the good intentions behind this bill. Unfortunately, the procedure proposed here simply cannot be squared with the U.S. Constitution. The Constitution guarantees every person accused of a crime the right to represent himself or herself. The U.S. Supreme Court has said, fundamentally, this is the right to have your voice heard. The procedure proposed here would literally silence the accused. The Supreme Court has said the right to represent yourself includes the right to control the questioning of the witnesses, and critically, it includes the right for the jury to perceive the accused person as his or her own attorney. The procedure proposed here takes away both. Second, the Constitution guarantees the right to effectively cross-examine the witnesses against you. Cross-examination is not merely the reading of a list of questions. It is not something that can be done by another person. Cross-examination requires responding to the witnesses in real time, adjusting your questions, and being able to change course immediately. The procedure proposed here effectively prevents all cross-examination, not of just any witness in the proceeding, what is likely to be the most important witness in the government's case against the accused person. Third, the Constitution provides every person accused of the crime the right to be presumed innocent. The accused person sits before the jury cloaked in that protection of innocence. This procedure strips away that protection. The only reason to use this procedure is because you assume the accused person is guilty, and the jury will understand that message despite any admonition from the judge. Fortunately, California courts do have at their disposal tools to address situations to protect vulnerable victims, and this bill is not needed. We urge your no vote. Thank you.
Senators, Matt Gonzalez, I'm the Chief Attorney of the San Francisco Public Defenders Association. The California Public Defenders Association is opposed to the bill. I just have a couple of comments. I think the standard is extremely low. I can't personally imagine a situation where a victim who is being truthful would not be traumatized in some fashion by having the person they're accusing walk into court. This is creating a scenario where a judge, if they find anything that is more than de minimis, would mean that somebody representing themselves would not be allowed to ask questions. I have to tell you that's an extremely low standard, because by its very nature, simply seeing the person, if they are guilty, who committed the crime would trigger that. My office in San Francisco does not allow any public defenders to participate as standby counsel in any case. It just creates all kinds of difficulties and problems, due process concerns, and we think it undermines an individual's right to represent themselves. I have often counseled accused individuals not to seek to represent themselves. I don't think it's a good idea, but once a judge makes a determination that they're capable of doing that, then I think it should be respected. Finally, let me just say, in all my years of work as an attorney, I have never a single time written out all the questions or even a significant portion of the questions that I intend to use during a trial. Typically, you've got areas that you're going to be going into. You've got documents that you might be using, prior testimony that you might use to impeach. And it's a very fluid process where you ask questions and try to respond to it. Judges have wide latitude to deal with a defendant that is being inappropriate toward a alleged victim. They can make that defendant stand behind counsel table. They can interrupt them if they're being argumentative, if they're asking irrelevant questions. They have a lot of power to do that, and there are even more severe things that they can do, like cut off cross-examination. So I would urge a no vote.
Okay, if there are others in opposition, seeing and hearing none, questions from the committee. Senator Leno.
Thank you, Madam Chair. First of all, let me thank Senator Royso for your very narrow approach to this. So I know you've limited to very certain kinds of crimes that have a significant emotional impact on the victim. The opposition makes some compelling points, and I especially make note that Mr. Gonzalez has pointed out that you have never suggested to a potential client that they defend themselves for obvious reasons. I've always wondered why someone would want to defend themselves. Even the most brilliant attorneys in the land use counsel for good reason. So I appreciate the position that a defendant is in should this become law, because there would be a suggestion to the jury that there is some guilt here and one needs to be presumed innocent until deemed guilty. But they put themselves in that position themselves. And to remove themselves from that position, all they would need is to take the counsel that the public defender in many cases is suggesting that they take. And I don't want to speak to the constitutionality of this. I'm not an attorney, and I'm certainly not a constitutional expert, and that potentially could be decided at some later point in court. But even though the judge would have the opportunity, as noted, to require that the defendant stand behind the table or to readjust certain kinds of questions, as the young woman here has already shared from your very horrific experience, just the fact of that individual asking whatever question, as reasonable, as respectful as it may be, I think can be a traumatic experience. I'm going to be supporting the bill today, and I would move it at appropriate time.
Thank you, Senator Leno.
I did.
Thank you. Thank you. Yeah, I'm wondering if, Senator Hueso, if you could respond to some of the issues raised by the opposition. I agree with Senator Leno that constitutionality will probably be tried in court at some point. But the situation that the judge has, especially that the judge has latitude to put a stop to any kind of harassing or up-close behavior on the part of a defendant in pro per.
Now, in that case, as I argued, as I believe this bill intends to inoculate bias because it'll create a state law on procedure, so it'll give the judge the ability to carry that out in a framework that is fair. So the intent is that the questions can be asked. So questions will be asked, and you can argue on the one hand that that there's more involved in cross-examining a person than just asking questions. I'd like to know what that is, because we also don't believe that anybody in particular should be terrorized or intimidated or harassed in that process. I think the root is asking questions. I think there will be a dynamic process by which the person defending themselves can amend questions and continue to ask. So it's a dynamic process. It's not set in stone in terms of, well, these are the list of questions and you're limited to that, and if information comes out that requires additional questioning, that will be allowed. It'll be a process that it will ensure fairness, that will ensure that information can be divulged. But what we need to do in the courtroom, what we have to do, is do everything to ensure fairness on both sides. So there's got to be fairness in asking questions, but there's got to be fairness in also allowing somebody to respond without feeling emotionally overwhelmed and feeling an enormous amount of pain, an enormous amount of anger in their answering questions. And we have to find a way to create a better environment in our courts for all parties involved. I think this bill gets us there. And I'll have to just respectfully disagree with the opposition on this, in that I understand what they're trying to protect. We're trying to protect that too. We're trying to protect that in a way that's respectful of all parties' feelings. Having a specific code, again, will inoculate the bias across the courtrooms in all our state. And that's the reason why we need to adopt that, to have that overarching requirement that doesn't necessarily create a bias in the juries in those cases, because again, we can invoke a state law that requires a certain procedure to be followed.
Okay, and well, I note that it does require a hearing, not in the presence of the jury. Am I right in that?
Yes. And
So-
if I can expand.
Yeah.
And we have authors' amendments as well that will help with this. They mentioned them, I just wanted it to,
Yeah, where are they? Because I don't think the committee has any.
the removal of the provision of the bill dealing with violent felonies where we narrow the law. And specify the standby counsel would be shielded from liability from both the state bar and the court simply because they are not hired by the defendant. So we need to ensure that they will be able to participate without feeling, exposing themselves to liability from the defendant, which is not their client. And it will specify that standby counsel can be the court, which is the judge himself, to assist in this process. And of course, the judge can also recommend an additional procedure. But this generally sets up the legal framework that the judge
Okay.
should follow.
Thank you, actually, because I was not aware that you were offering the amendments. The amendments basically strike the violent felonies, which was a very large catch-all that was of concern to the committee, but has the other ways, types of cases in which this would be used. They say the questioning may be done by the court or an individual approved by the court, which addresses some of the concerns about the unavailability of an attorney or the reputation of an attorney, and then says that intermediate standby counsel would not be subject to sanctions by the court or state bar. So,
Madam Chair, if I could just respond to, I think the sponsor is conflating two things that are important to separate. If a defendant representing himself is inappropriate towards a witness, there is no question that that should not be allowed. And there is either existing action the judge can take, which I believe there is, or you could make this law there then take effect and not allow that defendant to continue to handle the examination. But what this law does is it, before the trial begins, before the accused person has done anything inappropriate, it creates a de minimis standard where if the victim is going to suffer anything more than de minimis trauma, which I believe will occur every time somebody walks in the courtroom, because I do think it's a difficult situation to be in, that triggers this law, and every accused person representing themselves is going to have the right to conduct cross-examination taken away from them.
And if I may add, the case from Massachusetts demonstrates what's wrong with this procedure. In Massachusetts, they tried to use this, and the standby attorney was ordered to go back and forth to the accused person to have the questions changed through cross-exam. And midway through this process, standby counsel simply stopped and said to the court, I can't do this. This is not effective cross-examination. And ultimately, the Massachusetts reviewing court reversed the decision. And if I can say that that is ultimately the cost here. Yes, this will be decided by the courts. These cases will be reversed. If this gets to the U.S. Supreme Court, I will say right now, this is going to be reversed. And the result of that is that people who have been victimized will have to go through trials again. We all pay consequences when we make mistakes and we pass unconstitutional laws.
thank you, and I appreciate the strong feelings. I'm going to ask if the support also would like to take another minute to respond to those concerns, which I have to say are very compelling.
You want to say anything?
Thank you.
Yeah.
Thank you, Your Honor. We would like to respond to those. With all due respect, the Supreme Court has held that those rights of the defendant are not absolute and that they can be outweighed under certain circumstances when there is a compelling state interest. And here, I think we have found that compelling state interest to protect these vulnerable victims from further trauma, from being questioned directly by their accuser. These cases, there are cases that have held that this procedure can be used, and it can be done in a constitutional way. We are not going to try to put forth a bill that is unconstitutional and that causes retrials and cases to be overturned. So when you look at all of the cases that have dealt with this specific issue, there are certain things that need to be done to protect the defendant's rights, to make sure it is done in the proper way. One of those are the factual findings have to be made by that trial judge to show that this process is necessary and that victim is going to suffer trauma from being directly questioned by their attacker. The second thing that must be done is that the defendant still has to maintain control of his case. And we have made sure that that procedure is in place in SB 603 because he controls his questions. He makes sure that every question gets asked that he wants asked, and the judge will make sure of that. All of his questions will be asked. The third thing that must be done is that the judge must ensure that the jury understands that the defendant is still in charge of his own case. And in our bill, we make sure the judge instructs the jury of that the defendant still maintains control of the case, and that these are the defendant's questions being asked. So that is the process from the cases that have dealt with these issues, that if it's done properly, there is no violation of his rights. In that case in Massachusetts that was overturned, the court did not implement this procedure properly. They didn't find the correct factual findings before they implemented this procedure. And when they did implement the procedure, they didn't allow all of the defendant's questions to be asked. And so there were violations in the way that it was implemented. I think this is a further example of exactly why we need this, so that trial courts don't try to go out and just do it on their own without knowing the appropriate procedure.
Okay, thank you very much. Senator Weissel, would you like to close?
I think that was a good close, Madam Chair. I respectfully ask for your support for this bill.
Okay, the bill has been moved as amended to appropriations. I'm going to support the bill today, too. I thank you for narrowing the bill by taking out all violent felonies and really dealing with some of the very one-on-one kinds of issues that are sometimes faced in court, and also the fact that there is a hearing required before this goes into effect. I'm concerned about it. This is another one of those 51% votes that we had to take today, so I think we need to be watching to see what happens. But probably, if and when it's used, it will end up in court, and the courts will make that decision. Anyway, so the bill has been moved as amended to appropriations. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Leno? Aye. Leno, aye. Liu? Liu, aye. McGuire? Aye. McGuire, aye. Monning? Stone? Stone, aye.
That bill has enough votes to pass. The bill is out. Thank you very much.
Thank you, Madam Chair. Senators, thank you very much for your support.
We have two other, Senator Leyva. While she's coming forward, I take a motion on the consent calendar. There is one item, item 15, SB 674 by Senator De Leon. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Leno? Aye. Leno, aye. Liu? Liu, aye. McGuire? Aye. McGuire, aye. Monning?
Aye.
Monning, aye. Stone? Stone, aye.
Thank you. Welcome to the committee, Senator Leyva.
Thank you very much. Good afternoon, Madam Chair and members. Thank you for the opportunity to speak to you today. Senate Bill 651 expands the definition of a victim with the Welfare Institution Code so that it includes family members, guardians, and significant others as derivative victims of a crime committed by a minor. The changes in the definition would match the language in the penal code. Under the revised definition, direct and derivative victims are eligible for compensation for out-of-pocket costs that resulted from a crime committed against them by a minor. No victim should ever be in a position to not be eligible for restitution simply because of an inconsistency in state law. Here with me today is Sandy Carter with Los Angeles County District Attorney Jackie Lacey's office in support of the bill. Members, I respectfully ask for an aye vote.
Okay, no more than 2, 1 minute each. Welcome.
Good morning, Madam Chair and members. My name is Centelia Carter, and I'm a senior paralegal for the Los Angeles County District Attorney's Office, and I'm also responsible for drafting SB 651. In one of my previous assignments with the office, I was responsible for assisting crime victims in obtaining restitution orders in both adult and juvenile cases. Currently, the Welfare Institution Code does not mirror the Penal Code as it pertains to the definition of a victim. As a
I'll
result,
just point out, there is no known opposition to the bill, so you can be brief.
are there any questions?
Is she good or what?
Yeah.
Christine Ward, Crime Victims Action Alliance. We are co-sponsor on the bill. This bill simply gives victims of juvenile offenders the same right to restitution as provided to victims of adult offenders.
Thank you. Others, me too, please.
Madam Chair, members, Marty Veronica on behalf of the California District Attorneys Association, we're in support of this measure.
Thank you.
Madam Chair, Dan Fulsado on behalf of the Los Angeles District Attorney's Office. Ready to answer any questions.
Thank you. Are there any others in support? Are there speakers in opposition to the bill? Seeing and hearing none, the bill has been moved. Would you like to close?
Just respectfully ask for an aye vote. Thank you, Madam Chair.
Okay, the motion is do pass, period, right? Oh, no, well, I'm going to look at it. It is? Okay, do pass to appropriations. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Leno. Aye. Leno, aye. Lou. Lou, aye. McGuire. Aye. McGuire, aye. Monning. Aye. Monning, aye. Stone. Aye. Stone, aye.
Senator Anderson wasn't here. The bill has enough votes to pass. We'll leave it, the roll open for the absent member.
Thank you, Madam Chair and members.
Thank you. Senator Bates.